We are diving into a high-stakes sentencing hearing for Nicholas Corpus. He's facing a felony charge for allegedly choking his girlfriend for 30 minutes. But here's the twist. He's pleading no contest, claiming he's only here because the system is rigged against men. Is he a victim of a toxic relationship or a master manipulator? Let's break down the evidence.
I appreciate that you entered a plea of guilty because for myself and for the family, I'm glad we didn't have to see what it looks like this would look like on a video.
I chose not to go to trial because I don't think anybody is going to believe me. And 9 times out of 10, when you hear about something like this, normally you take the woman's side and you don't never believe the man.
I was under the impression that he had the gun, and that's why I found probable cause. Not that someone else had the gun and he's just standing there. He's like standing while black.
The testimony from the complainant if the complainant chooses to come?
I'm sorry, I don't understand.
Well, because otherwise the setting for the PSI is going to be a late date.
It'll be December 7th.
Will be December.
Okay.
Or if you all want to, if you all provide me with his criminal history, and of course, any other statements that you want the court to review. And if the complainant wants to come in and testify, we could do it sooner.
Well, I mean, we're going to have some witnesses, Judge, 2 or 3 witnesses. But we're happy to have this earlier setting if the court has time.
All right, Ms. Ferguson, can you set this? They're going to have witnesses and state if you want to bring the complainant in, you can bring the complainant in. Yes. But I am going to need his criminal history so I'll know what's going on there.
Okay. And say,
are you Mr. Corpus?
Yes, Your Honor. I'm Nicholas Isaiah Corpus.
All right. You entered a plea of no contest on October 16th. And the court requested the criminal history because otherwise PSIs are taking a long time because there are a lot.
yes, Your Honor.
And according to the plea bargain agreement, there's to be a cap of 7 years and the state is silent on your application. There's an affirmative finding and no contact with Brittany Flores. All right, the court has had a chance to review the criminal history. Defense, anything you want to say on behalf of your client or any witnesses?
Yes, Judge, I do have some witnesses.
Raise your right hand for me, please. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand. Could you state your name for the record?
Alberto Rodriguez.
All right, defense.
Thank you, Judge. Just step up for a second here. Okay. Alberto, how do you know Nicholas?
He's my neighbor, been my neighbor for 19 years and good friend.
How old was he when you first met him?
He was about 15 years old when they first moved in there.
And so you've known him for quite a long time for his life.
I have.
All right. And how did you first meet him?
It's a kind of a funny story. When they first moved in, Nick was outside mowing the lawn and fixing my mind because I came out and I was going to start mowing my lawn too or something. And he comes over and says, "Hey, I'll do your yard for $5. And I thought, $5? What's going on? And I said, no, that's okay. Not because I didn't want him to do it, but because I said, his parents are probably going to think I'm a jerk because I'm letting him do my big yard for $5. So that's kind of how we started our relationship.
So you've known him into his adulthood, correct?
I'm sorry?
You've known him into his adulthood, right?
Yes.
You told me he was kind of like a grandson to you. Would that be accurate?
That's how I see him. Yeah.
All right. So how do you see him interacting as he's lived there in the neighborhood?
He's younger than most of us. Our neighborhood is mostly semi-retired or retired, so he's the youngest probably person in the block. But he's never had any problems with anybody that I know of because he gets along pretty much with everybody that I see him with.
Okay, so you also mentioned that he offers to help you a lot in neighbors.
He does. Anytime I'm doing something, he comes out there and wants to, you need help or, can I help you? If you need anything, let me know. One time I was I bought a TV and it was a big old TV and I was trying to carry it in the house and he comes out there and says, "Hey, let me help you. Let's be carried in the house," and everything. So that kind of stuff. And I'm putting out Christmas decorations. Even my wife even tells him, "Nick, if you see Albert out there, don't let him get on a ladder. Call me." I said, "Okay."
All right. And so you've also seen him helping other friends.
Yes, his friends come over often, and he offers to help everybody. So he says his friends come over a lot to have their cars worked on because he's a pretty good mechanic and a little jack of all trades kind of. And they come and get their cars fixed all the time, and he does it quite often. Quite often, he works on his own cars. He likes to work on cars and stuff. So they come over. He's got a little computer and stuff. Hooks it up and tells them what's wrong and helps them fix it.
Just outside of helping people, you also have a lot of talks with him. Is that right?
Yes, because growing up, it's kind of hard, and we just sit out there, and talk about life and different things that that are going on with him. Like his jobs and stuff like that.
Asking for advice.
Yeah, yes, and I try to give as best as I know through my own experiences.
And today we talked about why he's here, that he is charged with a felony choking family violence with his girlfriend.
Yes.
Okay. And so we're here today asking the judge to not send him to prison and to allow him to have deferred so he wouldn't be a convicted felon.
That's right.
Why do you think that he's lived his life, so he deserves to have that chance?
Because, like I say, he's helpful. He's a good kid in my eyes. I've never seen anything wrong. He's always polite. Always says hello, how you doing, and what's going on, and stuff like that. So, I don't see the benefit of him having to go to jail over. I don't know the circumstances completely of whatever happened. Only what I hear, but I know Nick, and I think he would do good. He's a good kid.
But you say you don't know the circumstances, but we've talked about the case, right?
Yes, we did.
So you understand that the allegation is that he choked his girlfriend, Brittany, multiple times, on and off over a 30-minute period is the allegation.
Uh-huh.
On and off for a few minutes in 10 or 15, intervals. That's what she's accused him of.
Yes.
And that saying that he hit her eye, that she had a black eye.
Correct.
All right. And so you're aware of all the allegations.
I am.
And you still think that he deserves to have a chance for deferred?
Yes, ma'am, I still do. To say that, I think Nick is still a good person.
The defense is playing a classic hand here, the character parade. They brought in neighbors and church friends to paint Nicholas as a helpful, God-fearing mechanic who rescues paralyzed dogs. Legally, they are pushing for deferred adjudication. This means if he stays clean, the felony never goes on his permanent record. But wait for it. The prosecution is about to drop the medical reality of the victim's injuries.
Inside, and I think he would do well still.
I'll pass on this.
Nothing from the state.
All right, thank you. Call your next witness.
Thank you. Thank you. Renee Ruba, yes, I know I'm not saying. All right. And how do you know Nicholas?
Nicholas has been my neighbor for the past 3 years. He's been a real good friend.
Okay. And can you tell the court a little bit about his interactions in the neighborhood and with you?
He's real friendly with everybody. I don't know anybody who has any problems with him. It's like he's always willing to help everybody. Been times where I've been working on my cars. I don't even call him or anything. He'd be passing by. He stops and gives me wrenches or whatever. He starts working on cars with me. I've had him at my house for barbecues and stuff, and never had any problems with him. He's always friendly like with everybody.
Okay. And so his mom also lives there with him. Is that correct? Is his mom?
Yes.
Okay. And can you know a little bit about his mom and her situation? Can you tell the court about that?
Pretty much, she has cancer, so he pretty much spends his day to helping her with everything she needs. So pretty much that's his a care provider, pretty much almost.
Okay. And he also is a pet owner.
He has a Shar-Pei that's actually paralyzed, and he actually manually has to help the dog so he could relieve himself and stuff. And pretty much that's almost like his kid, pretty much.
And so he helps other people in the neighborhood as well. Is that right? You didn't express that.
Yes, it doesn't matter what job it is or if it's dirty or not. He's always willing to go, and without you even asking him, he starts helping out and everybody. And it doesn't matter where it is. He's got to. If he has to drive somewhere else and they help you, he'll do it. It's like with nothing in return. Pretty much that's what he is.
Is there anything else you'd like the court to know?
There was one instance where we were actually helping them move to one of the houses.
Who's them?
We were helping Nicholas and Brittany. And while we were moving the stuff, Brittany was carrying a box and she was in front of us. And she tripped and fell forward. As Nicholas tried to help her, she actually got kind of aggressive and pushed him back. All he did was kind of move back, and we just kind of like said, you know what, let her cool down. That's one thing that I did notice that was kind of odd or awkward.
Have you ever noticed him in any aggressive or violent interactions with anyone?
I haven't. Everybody, they hang along with him. It's like, no, I don't know how you could hate him or anything, because he's always friendly. He's always willing to help everybody.
You understand he's charged with
Yes,
choking Brittany.
Yes, I do.
And that's a felony offense.
Yes, I do.
And we talked about the circumstances of what exactly she alleged happened. Is that right?
Yes, but it just doesn't seem like it's in his character. He's never been aggressive towards anybody.
And you understand that we're asking the judge not to send him to prison, but to give him an opportunity at deferred, which would save him from being a convicted felon?
Yes, I am.
Why do you think the judge should take a chance on him?
Because he's a real good neighbor. He's always willing to help everybody. And it's like I said, it's not one of those where he's helping people because he expects to get paid or anything. He's out there just to help everybody. He goes to church. He goes everything. That's why when they told me about this, it just seems so out of character.
I pass the witness.
No questions, Your Honor.
All right, thank you. You may call your next.
Thank you, Judge. Eduardo, how do you know Nicholas?
I've known Nick for 13 years. I met him first at the gym.
Okay, and so you continued a friendship from that?
Yes, ma'am. We've continued a friendship for the past 13 years. We've also attended church together. I invited him on an Acts retreat to St. Paul's, and he went. And since then, he has become a member of the Armor of God Society at St. Paul's. We meet on Wednesdays and Saturday mornings.
Okay, and what is that group?
So if you've been on an Acts retreat or if you just want to get closer to God, we invite men to congregate to praise and worship and just honor God.
And so how long has he been participating in that?
The Armor of God meetings, probably 8 months, 9 months, somewhere in there.
And have you ever seen him have interactions with people that are confrontational, aggressive, or violent?
No, ma'am.
You also said that when we were talking that you believe he would be able to be successful at probation. Why did you feel that?
To me, he's demonstrated character, consistency. I own a construction business, and Nick has worked several jobs for me. Never let me down on one of the jobs. So I feel he's consistent.
So he's made commitments to you and always followed through?
Yes, ma'am.
Is there anything else you'd like the judge to know?
I just don't believe what he's being accused of. He's never demonstrated any violence to me. I've never seen him raise his temper. I've never seen him raise his voice. It just seems completely out of character to me.
And we've discussed the charge and what the allegations are.
Yes, ma'am.
Detailed, right?
Yes, ma'am.
Why do you think the judge should take a chance on him and allow him to have a chance at deferred instead of convicting him or sending him to prison?
Nick is a good guy. He, like I said, has never let me down. I know he won't let you down. He's just distributed, been really good character and a really good guy.
I'll pass the witness.
Any questions?
Just 2 questions, Your Honor. Sir, were you aware that the defendant's statements on scene were that she punched herself in the face?
Was I aware of this?
Were you aware of that statement?
I believe you told me yes.
That he had said she punched herself in the face?
No, I didn't know that.
You didn't know that.
No.
And were you aware that she wasn't able to open up her swollen eye for over a week after the incident? Were you aware of that?
No, sir.
No further questions.
No questions, Your
All
Honor.
right, thank you.
Thank you. I don't have any further witnesses, Judge, just argument.
All right. The state is silent. The court will hear argument.
Thank you, Judge. Judge, and just to bring your attention, you are aware that my client did plead no contest. I know a lot of people plead no contest just because their attorneys tell them, but really what I explain to my clients is what no contest means is I don't agree with this, but I'm not going to fight about it. And we also worked in conjunction with the prosecutor in his plea paperwork. We took out the statement saying that everything was true and correct because we don't necessarily agree with the allegations. But my client decided that he would rather go forward with you, Judge, rather than go into a trial because he does not want to risk a felony conviction. He very much wanted to apply for deferred. As you see on his criminal history, the only thing he's ever had on it was a marijuana charge, which was deferred, dismissed. So he successfully completed that probation. And that was when he was much younger. He has not had any other drug cases or any other kind of cases until this allegation came about. And so, Judge, what I wanted to do, the reason why I wanted to have these witnesses is because I wanted to put in front of you not just a defendant who is charged with a felony choking case. I wanted you to see the man that he has been and the way he's lived his life. And I understand there's a statement and the complainant, Brittany, had made many statements. I'm hoping based on his history, based on the way he has lived his life, that although there is this one incident, that you'll give him this one opportunity to defer. I think that he does deserve it. Judge, and I, based on my experience with him and all the conversations I've had with the people that know him, I do believe he will be successful. He was certainly successful before, and I do believe he will still be successful if you'll give him an opportunity to not have a felony conviction, which will stop him from having the good jobs that he's had. It will cause so many problems, and I don't think that's the best for the community. I know that you can put whatever conditions that you feel would be safe. The only firearm that he had there was at the house was left with the complainant, Brittany, and we don't really know what happened to that. We got word from the family that they had turned it into SAPD. We can't get any confirmation on that. He is not in possession of any firearms. He has no intention to be in possession of any firearms. I did note on the medical issues, I just wanted to make the court aware. She has said that she's had ongoing headaches besides the emotional difficulties that she described, the physical problems, and that she's gone to clinics and such and has spent some money. She was prior in an accident where she went through the windshield, and she's always had the headache since then and the physical problems. So whether or not anything else contributed, Judge, I just thought the court should know that we're not opposed to paying restitution if the judge gives them an opportunity to do the deferral of probation, to take care of whatever's needed. I'm sure she has receipts and that sort of thing. Judge, I just implore you to please give this man a chance to not be a convicted felon. I don't think you'll regret it.
All right. So what I can tell you.
The judge isn't buying the nice guy routine just yet. She delivers a massive reality check. Nicholas isn't going home today. It's either a cage or a high-intensity probation program. Now, in a risky move, Nicholas takes a stand to tell his side. Watch his body language. He's about to shift the entire blame onto the victim.
Mr. Corpus, is you're not going to be leaving the courtroom today. Either you're going to prison, or either I'm placing you on probation and you're going to ISF. So I have some questions.
It's a drug.
All right. Can you raise your right hand for me? Do you
Yes,
solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I swear.
All right. You can lower your hand. What happened that day?
So that day, I came home from work.
And just so you know, if you veer off and you are not truthful, the state, even though they're silent, they'll get a chance to ask questions of you. So what happened that day?
So I worked all day. I got home about 7:30, 8 o'clock in the evening. I started cutting the grass at our new home that we had. I was outside, I had my music on. I had bought a 6-pack of beer for me, 6-pack of beer for Brittany. I was waiting for her to get home so that we can go out and buy dinner together. She got home, and normally what I do is that I'm the cooker. I cook and I wash dishes, and that's my job while she studies, because she's currently going to school. Well, she came home in a very bad mood. She asked what was her dinner. I didn't cook it because I was tired and I wanted to buy us dinner. She went inside, slammed the door. I stayed outside listening to my music. I went inside a little while later. I said, what would she like for dinner? She said she didn't want no more dinner. I said, okay, I'm gonna go back outside. I went outside and I started drinking my beer. After I drank one beer, I went back in, said, baby, I would like to cook you dinner. I'm sorry I didn't cook it. Said, no, this, and that. She just started acting irate. She normally does. She has an anger issue that I've been dealing with it for the past 13 years, being with Brittany. About 8 to 10 years, her living with being my mother, and the rest with us going to different apartments and different houses together. So I broke up with her. I got tired of the way she treats me.
No. We're back to that night, because you didn't break up with her that night,
I
did
broke
you?
up with her that night.
All right.
And that's where the argument started, because we had just purchased the house and our new vehicles together. So I ended up leaving her with the mortgage.
No. When you say you broke up with her that night, what did you say?
That I'm leaving you. I'm packing my things and I'm taking my dogs with me.
Okay.
And I'm leaving. And she's going to have to pay for the house herself, the cars herself, because she states so much that it's her house, they're her cars. So I left her with it. And that's where she wouldn't let me pack my things. I was putting my clothes in my bags, packing up my dog's wheelchair, packing up my animals, their beds. And that's when she kept pulling me back, grabbing my clothes, throwing my bag on the floor. When I would try to leave, she ended up tackling me on the sofa, wrestled around, got up, got tired of her hitting me. I walked out the door. I said, I'm gonna call the cops on you. I'm tired of you. This is the last time that you hit me. We're literally fed up with it.
Did you call the cops?
I shouldn't have opened my mouth, because when I went outside to call the police, I dialed 911. And I didn't want to ruin her life, because I know she has a very good career. So I decided not to. But where I messed up is that I told her I was going to call the cops and they were going to take away her concealed handgun license for assaulting me. So decided not to. I called my mother, told her what happened. She told me just to get my things and leave. I said, no, I can't leave. I drink a beer already, so I'm not going to drink and drive. I'm going to wait here till the morning. I'm going to sleep outside in the porch with my dogs, and I'll leave in the morning. I'll go to your house. About an hour or two later, the police get there, and I was still outside on the porch with my dogs, and she was inside screaming, yelling, just acting insane. And then they told me that.
Did he really just say that? Nicholas is claiming his girlfriend, who had a black eye so bad she couldn't open it for a week, actually punched herself or slapped herself to frame him. This is a massive gamble in front of a judge. Quick poll for the comments. Do you think a person would actually inflict that level of injury on themselves to win an argument?
They're there for me, not for her.
Okay. So how did her eye get swollen?
So one thing that I have been dealing with for years already with her is she's a self-inflicting kind of person.
So how did her eye get swollen?
So I would say that she was inside slapping herself, hitting herself. I can't say punching or slapping because I wasn't there.
So are you saying that you never hit her, you never choked her? Because that's what we're here for.
Yes, ma'am, I do understand this. And it is something that I've been dealing with for years with her mental issues. With
My
her
question is,
harm.
are you saying that you didn't hit her? Yes or no?
I am saying that I did not hit her, Your Honor.
Are you saying that you choked her? Yes or no?
No, Your Honor.
Well, it sounds like he should be in a jury trial.
Judge, we discussed that. But why did you not? May I ask him some questions, Judge?
Sure.
Why did you choose not to go to trial?
I chose not to go to trial because I don't think anybody is going to believe me. And 9 times out of 10, when you hear about something like this, normally you take the woman's side and you don't never believe the man.
Oh, I listen. Let me stop you right there.
I'm not saying you yourself.
Okay,
I
because
apologize.
everybody will tell you I evaluate everything.
I apologize saying you.
Okay.
Judge, we were asking why he didn't want to go to trial. So he's referring to the jury. He decided to go in front of you because, well, I've discussed that you do listen.
Okay.
Okay.
I didn't want a conviction on my record because of my good jobs that I've had throughout my career. I've been an outer body technician. I've also been an electrical engineer working for the San Antonio State Hospital for the past 6 years. I paint cars. I'm also a mechanic. You name it, I can probably do it all. I've had all kinds of trades under my belt. And with this conviction, it would make it to where I probably wouldn't be able to get a good, decent job anymore or actually work for the state ever again if I were to become a convicted felon.
And Judge, we discussed the difference between getting a conviction and having deferred, and that the only opportunity for him to have deferred would be to waive his right to a jury trial and go to the judge. I do have some additional questions.
Sure.
You're aware that Brittany has stated that she doesn't feel safe anywhere,
Yes, ma'am, I am aware.
but there have been a couple of occasions when she's come over to your house where you're living with your mom. Is that correct?
Yes, ma'am.
What was the first occasion?
Objection relevance. This is post date of incident, correct? The question you just asked is post incident.
It is, however, since the judge.
Right. That'll be overruled. You can answer the
Thank
question.
you, Judge. I'm sorry.
The defense just flipped the script. Nicholas is claiming that after the arrest, the victim was the one stalking him, showing up at his house and offering to drop charges if they got back together. He even claims he recorded her. If true, this complicates the fear for her life narrative. But the prosecution is waiting in the wings with the police report in hand.
Can you tell us about the first occasion?
Yes, ma'am. About 6 days after I was released, give or take a few days, I was there at my mother's house, and
What were you doing?
I was outside. I just got home from my sister's house. She lives a block away. She cooked me dinner, and I ate dinner. It was about 9:30 at night by the time I got home. She lives 1 block away from my mother's. I got home, and she was parked outside my house, and she had asked me to get back with her, and that if I did, that she wouldn't press charges. And as she was doing that, I took out my cell phone, and I started recording her and her car and her license plate with her voice in there. I wasn't able to catch what she was saying because by the time I started recording her, she started leaving.
And did you make a report?
And I made the police report, and I showed the video to the officer, and he actually recorded it on his body camera with my phone in his body camera.
Okay.
And then
The second event?
2 weeks ago, I was outside my mother's house cutting grass, and she ended up passing by again and stopped to see how I was doing. She said, "Oh, you're cutting grass, huh?"
And what did you do?
I made the police report, and I took down her license plate number, and they came and they gave me a case number and told me just to relay it whenever it came down to it.
Have you, since this case, reached out to her at all?
No, ma'am, I have not.
And do you have any firearms in your possession?
No, ma'am, I have 0 firearms in my possession.
You had 1 firearm at the time of the incident. What happened to that?
That firearm at the incident, I left it there with Brittany, and
So do you know what happened to it with personal knowledge?
I do not know.
What did your mother told you something. What did she tell you?
When my mother went to pick up my paralyzed animal, her mother was at the door.
Brittany's mother?
Yes, along with Brittany herself, and they told my mom that they turned in my firearm to SAPD.
Have you been able to confirm that with the SAPD?
No, ma'am. I've been calling property, but I haven't been able to get an answer.
And why did you want to know? What were you worried about?
I'm worried about what actually happened to it because she has a very dysfunctional family, drug addict brothers and sisters, and I just can't trust those people when they're the kind of people that they are.
And was the gun registered in your name?
It is registered under my name, yes, ma'am.
And so you just wanted to make sure it was in safe hands?
That's it. I just want to make sure they actually turned it in because I don't want them to turn around and use it and it go against me, and I don't want to get in trouble for something that happened like that.
Thank you. I pass the witness.
Any questions?
Yes, Your Honor. If I may just bifurcate my questions into 2 separate fact inquiries. Defense kind of opened it up, so we'll talk about post date of incident. You've conferred with your attorney, correct, and gone over defenses you can provide, and she's gone over the evidence with you, correct?
Yes.
And are you aware that the complainant told the DA's office that she actually believed this was attempted murder and that you threatened to stab her and shoot her that night? Were you aware that she told the DA's office that?
Yes, that's what I actually had on.
Yes, that's perfect. No, I appreciate you answering that. Thank
Judge, he can answer the question.
All right, so everyone, just answer questions. Everybody calm down. I have listened to everything. I read the reports. So just answer, let him answer, and we'll go from there.
Okay, you can give your full answer now to that question.
Can you ask me the question one more time?
I'm happy to move on to the next one.
Judge, I'd like him to have an opportunity to answer the question.
All right, so ask your question, counsel.
The same one, Your Honor.
You can either ask the same one or you can ask the next one.
Thank you, Judge. Were you aware that as recently as October 6, 2023, the complainant has told us that she still has safety concerns as they relate to you?
I'm not aware because I'm not in contact with her at all in what means whatsoever. October 6th was just a month ago. And
here comes the gotcha moment. The prosecutor's pointing out that Nicholas's story in court, the couch, the wrestling, the self-inflicted injuries, is nowhere to be found in the original police report from that night. In fact, he's even contradicting who he was drinking with. When a story changes this much between the crime scene and the courtroom, judges usually see red. Is he digging his own grave? Let's see how he handles the heat.
No, I'm not aware.
You recently just spoke on the record about she basically tackled you on the couch and sofa. You actually had an opportunity to speak with the police that night, correct?
Yes, sir.
And does it surprise you that the word sofa or couch is nowhere mentioned in the entirety of the police report?
It does not surprise me.
The night began, again, just speaking to facts, the night began with you drinking beers with the victim's brother. Is that correct?
No, I didn't.
Okay. How did the night begin?
The night began with me getting home that night and me not cooking dinner because I was tired. But I started cutting grass instead, and I was waiting for her to get home so we can buy dinner.
Does it surprise you that you told officers that the night started because you guys were drinking beers together and he left because he was crazy just like her? Do you remember saying that to officers?
No, I don't.
Do you remember saying that when the complainant got home, she started, quote, just hitting herself in the face for no reason? Do you remember saying that to officers?
I do remember that.
Do you remember calling her a psycho?
Yes.
Do you remember saying that you never hit her?
Yes.
Do you remember saying that you had no reason why her eye was swollen to such a great extent that she actually couldn't even open it? After you had previously said that she punched herself in the face. Remember, kind of those conflicting accounts.
But I can understand why you're trying.
So let me break it down. Absolutely. First, you told officers that she started just punching herself in the face for no reason. Then you said you had no idea why her eye was swollen. Do you have any recollection as to why you gave conflicting accounts?
Because she started doing it when I had told her that I'm going to call the police on her and have them take away her concealed handgun license for assaulting me.
And then do you remember the officers noting that they believed you were intoxicated, even though you just spoke to only having one beer?
Well, no, actually, I told the officers that I had that one beer, and when I went outside on the porch, I started drinking myself to sleep on a concrete porch. So I can stay home, wake up the next morning, pack up my things, and go to my mother's house.
So does it surprise you that both the victim and the officer on scene believed you to be drunk that night?
Well, like I said, I started drinking myself to sleep on the concrete porch. So I was not inebriated. It was a 6-pack. I believe I was on beer number 4 or 5.
No further questions, Your Honor.
No further questions, Judge.
All right. Are you employed?
Yes, ma'am. I work for Dr. Richard Kimball in Hinojosa for Richard's Electric.
Mm-hmm.
But one thing that's going to cause an issue is that he's moving to West Virginia. So I'm going to need to find another place of employment, in which I was hoping that my ex-brother and friend, Mr. Danny Garcia, would hopefully be able to employ me with this company.
All right. This is what the court is going to do. There's an affirmative finding of family violence. There's to be no contact with Brittany Flores. 10 years deferred adjudication. The BIPP course. Proof of employment within 30 days of release. There's to be no harmful or injurious. There's to be no employment as a home health care provider with minors. regular reporting by Zoom or in person, GPS partial for employment until further notice. There's to be field visits 1 time per month for 3 months, regular UAs, TAP evaluation while in custody, follow all recommendations from TAP. What's the wait time for ISF cognitive?
About 40 days.
All right. And he is to be ISF cognitive track. Probation, is there anything else? Understand?
I understand, Your Honor.
All right. You are not to have any contact with her. Do you understand?
Yes, ma'am, I fully understand.
Your relationship with her is over. She doesn't want to be with you. You've informed the court you do not want to be with her. Do you understand?
I understand.
There's to be no contact with her through third parties. There's to be no contact with her mother, her relatives, or anyone that she knows. If you see her and if she's at the HEB, you need to leave the HEB. You understand? If you see her walking on the sidewalk, you need to go in the opposite direction. Do you understand?
I understand.
There's to be no card sent to her saying, I'm sorry. There's to be no flowers for old time's sake. It is as if you do not know her. If you have contact with her, you're looking at potentially 10 years in the prison. Do you understand?
I understand, Your Honor.
All right. Good luck to you.
Thank you, Your Honor.
The city of Port Arthur is asking for continuous prayers to comfort the family of a city employee killed in a crash. 47-year-old James Addison died following the Friday night collision. He was employed as an equipment operator in the Port Arthur Public Works Solid Waste Trash Division since 2018. 40-year-old Christopher James is charged with intoxication manslaughter in the crash that killed Addison. At last check, James remained behind bars on $30,000 bond. Port Arthur Mayor Thurman Bartee told Armello Stiles the city lost a good employee when a driver crashed into his motorcycle at 11:40 p.m. on Friday in the 100 block of Gulfway at Houston Avenue.
Are you Christopher James?
Yes.
And Mr. James was previously in court, entered a plea of guilty to the first-degree felony offense of intoxication manslaughter with a vehicle. I've received the pre-sentence report and also a supplemental memorandum from probation that includes several letters from the victim's family members. Has everyone had an opportunity to review all of that?
Yes, yes, we have, Your Honor.
Are there any additions or corrections to that pre-sentence report?
No, Your Honor, I just want to make the court aware Mrs. Addison, the deceased wife, would have been here today to do victim impact. She had to go to the hospital yesterday. She's able to tune in, I believe, and watch us. The rest of Mr. Addison's family is here, and his mother is going to want to do victim impact in the sentencing.
Okay, thank you, Mr. Nichols. Any witnesses with regard to sentencing?
No additional witnesses, Your Honor.
All right, Mr. Lewis, you may make argument.
Okay. Judge, of course, this was a very tragic situation that has affected a lot of people. Mr. Bush, the decedent, Mr. Addison, his family, as well as Mr. James and his family. It was a situation where, this was a combination of a long substance abuse history of Mr. James. The assessment that's provided in the PSI here says that there was about a 20-year relationship between Mr. James and different substances over a period of time. We have, the one thing I can say is that once Mr. James went through this situation with this accident, he has been doing everything he can to try to better himself. He has got his high school diploma. He's was baptized and has definitely changed his ways and going to his faith and continuing in that regard. He's also got some different certifications that he was able to receive dealing with OSHA, I think it was Men's University, things of that nature to try to better himself, Judge. Now, it's no secret he does have a long criminal history that even included dealing with PCP, which is the same substance that was involved in his accident. And as well as uh, other serious offenses. I do want to address something as far as I know there's some situations we're dealing with the jail instances, and I know how the court proceeds or looks at the situation you're dealing with those. Mr. James, if you look at these situations, majority of them did come from situations involving him and other inmates, as far as any type of fight or anything like that, which unfortunately some things he can't avoid. But as far as anything dealing with being disrespectful, anything towards jail employees or things of that nature, there's one situation I think that they were talking about that it wasn't an actual write-up, but it was notated. He has been a trustee over there for a period of time at the jail as well. Now, I do want to point out that, of course, some of those situations that Mr. James was able to do to better himself, of course, could definitely increase his earning potential as far as what he has as far as the job situation. He does have significant family support. His brother is here today in the courtroom, who in any way is able to try to help him, including helping secure employment. My understanding is the plan, once he is able to be released, is for him to be moved to Houston, Harris County area, to be close to his brother, to help him with everything over there. Now PSI did have a recommendation for his different vehicles that support that's available to him through the probation department. What I will say is that everything that has been recommended, he definitely needs and will be better for him. We are not, and ourselves are not asking for a specific number or anything like that. We just want him to be able to, of course, make amends for this situation as much as possible, which could include some of the restitution there. I think the amount is over $100,000 for his restitution there to the family. Now, like I said, he has made a plan to try to better himself. He has a family that supports him. He is doing everything he can. He understands that this was a tragic accident, but one he was definitely responsible for. And what we're asking for is as much leniency as possible from the court, for him to be able to move forward with the situation, be able to make amends as much as possible. And I think he did provide a letter to the court as well to kind of speak to that, as far as an apology letter that was to the family, his family, the family of the victim, as well as to the court judge.
And I've received that.
And so that's what we're asking for today, Judge, is for everything to be considered. We understand this is, you can't bring that person back. You can't just go back to make amends with Mr. Addison, but he wants to try to make as much of amends he can to society and do better going forward.
Thank you, Mr. Lewis. Mr. Nichols.
Your Honor, I think any consideration to Mr. James's due was given when he got a 50-year cap. I have no hesitation asking the court to exercise the full 50 years. This case is one of the worst intoxication manslaughters. It's on video where he plows into Mr. Addison, who's at a stoplight on a motorcycle, and while trying to get away, runs over him and the motorcycle again. It's horrific, Your Honor. What is also just inconceivable to me is that a man who's on parole for several possessions of phencyclidine, PCP, finds himself behind the wheel on PCP again. And this time it ends in the death of somebody. His criminal history is extensive. It starts with minor drug offenses, then a conviction for aggravated robbery, and then I believe it's 5 drug convictions all at the same time in 2020, for which he was quickly paroled out and on parole when this happened. The fact that he gets to make plans in his mind for a day he's set free, I find rather offensive, and I think the Addison family finds offensive. They lost a son, a brother, a husband. There's nothing we can do in this courtroom makes that better. And sometimes the justice system is a poor substitute for what people lost. I think the best we can do at this point is this man spend 50 years in prison where he cannot hurt anybody else due to his own selfish decisions, and continued use of substances. It's in the pre-sentence report. He minimizes his own addiction, his own dependency. He even claimed he did not know how he could have gotten PCP in the system the day this happened. That maybe he touched a bottle and it transferred through his skin, and I find that reprehensible, Your Honor. And that's why I'm asking the court for that full 50 years.
Thank you. So, Mr. James, a couple of things that Mr. Nichols didn't say that I think are also extremely important is this isn't your first driving while intoxicated. This is your third. And so you didn't learn in 06. You didn't learn in 2017. 2017, you got your second DWI. You were given probation. It was revoked. I appreciate that you entered a plea of guilty because for myself and for the family, I'm glad we didn't have to see what it looks like this would look like on a video because it is just horrible. And the fact that you are truly saying that you think you touched something and got PCP when you have had PCP cases over and over and over again, and you're on parole for possession of a controlled substance and you kill someone. It's a nightmare. Sure, go ahead.
No, that night that accident happened, I was back clean. The entire town was all cool. Okay, so I stopped off at a friend's house and gave him some advice about what he was doing. And during that time, I did contact a violent fears. I was not high at that time at all.
It was in your system.
Yes, ma'am. You know how I fight you.
At this time, based on your history, based on the nature of this offense, I'm going to find that you entered your plea of guilty freely and voluntarily. I'm going to find sufficient evidence to find you guilty, and at this time find you guilty of intoxication manslaughter. I'm going to sentence you to a term of 50 years in the institutional division of the Texas Department of Correction. There will be a deadly weapon finding based on the indictment alleges a deadly weapon. You will receive credit on this sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows this was an agreement and I followed it, and so you waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Lewis. There's really so many other things I could say about how horrible this is, and rarely am I out of words, but I really don't have the words to say what a tragic circumstances based on your behavior this led to. Y'all can have a seat at council table for the victim impact statement, and we'll go off the record.
Under a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
That's right.
Okay.
On September 30th, 2024, officers were dispatched to a weapons disturbance call in Harris County, Texas. The caller advised that he observed a group of juveniles with a handgun after walking into a Texaco gas station. The caller asked the defendant if he had a gun, to which the defendant stated yes, and that he had it for protection. The officer observed the group walking away from the gas station and activated his lights and sirens. The defendant began to evade upon seeing the officer. The officer had prior interactions with the defendant and knew him by sight and name. The officer later was able to locate the defendant at his residence.
So you said that he goes into Texaco.
Your Honor, the complainant was walking into Texaco and observed the defendant with another group of juveniles outside the gas station with a handgun. And then
Okay, so who has the handgun?
the handgun is with the defendant. And the defendant,
He has a handgun?
yes, the defendant said he had that for his protection.
Read it again.
Yes, Your Honor.
I must be confused. Read, please.
Yes, Your Honor. The officer was dispatched to a weapons disturbance call in Harris County, Texas. The caller advised that he observed a group of juveniles with a handgun after the complainant walked into a Texaco gas station.
So you have, see, this is an unknown caller.
Yes, it is the caller.
And, hey, I saw a gun here.
I saw a gun with a group of juveniles. And the caller asked the defendant if the defendant had a gun, to which the defendant stated yes, that he had it for protection. And then the officer observed the group of juveniles walking away from the gas station and activated his lights and sirens. And the
That's when
defendant,
they all like
that's when they
scam.
Yes, Your Honor.
You were on bond for 3 felony cases. I have to imagine that one of the conditions that you're on bond for is no weapons. And now you've picked up another case.
So,
Stop, don't sing. Mr. Joyal, I'm going to find that there's probable cause to go forward with your case. What time of day or night was this?
Your Honor, let me check the offense report.
it appears to be at,
I apologize. I don't know military time, but 13:26 hours.
It's 1 in the afternoon.
1 in the afternoon, Your Honor.
So he's got the 3 felony cases upstairs. They're all no weapons as well. You need to understand that by picking up this case, it's very possible that they revoke your felony bonds and raise them. And if that happens, 3 felony warrants are going to issue for you. So you need to get with your lawyer extremely quick. No, don't. But I am ordering you now as a condition of your bond not to be in possession of weapons. And I'm also ordering you not to use or consume any alcohol or dope. And I'm going to drug test you today because I want to know what, if anything, is in your system. You're to come right back and then we'll talk about your lawyer situation. Do you understand?
yes, sir. Yes, Your Honor.
I was appointed on this case today.
Okay.
Judge, I wanted to see if we could hear probable cause on this. I have an issue with him being arrested for this. I wanted to see if we could hear that.
What's your problem?
Judge, if I may, so this OR reads, a group of individuals have a gun. It's impossible. A group of individuals can't have a gun. Somebody, one person has a gun. Now, furthermore,
So that alerts the officer of a problem, and then he comes to do a further investigation. I get that in and of itself is nothing, but then they go to do a further investigation, right?
If I can make another argument, Judge, the person states that he talked to the person that has the gun, specifically talked to the one person that has the gun, and he stated, I have the gun for what, my protection?
Yes, for protection.
That's him.
No.
You told me it's him.
The initial caller stated he asked the defendant if he had a gun, and then that's when the defendant stated yes, and he had it for protection. In the DMs, it says the defendant.
It's not, there's 2 defendants. There's 2 people arrested. One that actually had the gun. My client doesn't have the gun. He was arrested for evading. There's no gun found on him. The other gentleman was arrested for possession, I believe. A Mr. Kenneth. If you look at the OR, it's in there. There's somebody else was arrested. He wasn't found with the gun. It's not my client.
Well, it says that the defendant was identified by the caller from prior booking photographs. The caller is the one who said that the defendant had the gun.
Yes, Your Honor. It was the caller that identified the defendant and the one that spoke to the defendant who had the firearm. And they were shown booking photos, and they identified the defendant, Mr. Joyal.
Judge, I asked that they look at the OR and see who actually got arrested for possessing the gun.
Judge, I think it was the co-defendant that had the gun. He's the one that was charged with unlawful possession of a firearm by a felon. This defendant,
The other co-defendant has the gun.
I believe so, but that doesn't justify this defendant running away after they established probable cause to detain. That's the state's argument in our position for probable cause.
What was he doing wrong?
Somebody had a gun
That gives them.
Get it? So that's why that person got arrested. But
That didn't just happen in that order. It's not, they stopped, they detained.
I was under the impression that he had the gun, and that's why I found probable cause. Not that someone else had the gun and he's just standing there. He's like standing while black. You know, he's like,
We talked to the person that had the gun. Identify.
hey, if you can show me something that he's doing something wrong, then okay. But I was under the impression that he did that and then he takes off, hence the evading. If he's take your time, there's no rush, right? But if he's doing something wrong, then they're going to investigate him for doing something wrong, and he takes off. That's a different question. But if he's doing nothing wrong and just standing there, no.
And this guy that they talked to,
hold on, I get it. Let me see if they have anything else. If not, then I'm gonna cut him loose.
Sounds good, Judge. Have a seat, please.
Okay.
Judge, so I'm going off of the OR. There's a couple of descriptions that are in here. So, first, there's two people that seem to be involved. One is the store clerk, and then one is the person that says he sees somebody dumping a gun. Now, we don't know what description is what, but under the point where it says prohibited weapon suspect, the suspect was described as a black male wearing a black shirt and two-tone colored jeans. It doesn't say who's making this description, whether it's the convenience store person or this second witness.
So, and Ricardo, I can clarify that. Judge, we called the officer beforehand. They indicated that they did not know when they came up who was there, like who exactly had the gun. We listened to the 911 call. The 911 caller just indicates there's a group of juveniles. There's three black males, 2 Hispanic, 1 white, and one of them indicated to me that he had a gun, one of the black males. But at that time, they didn't have a description, a decisive description to indicate it was one of those males.
Like in this case, if he was Hispanic,
yes,
there'd be no probable cause. If he was white, there'd be no probable cause, right? Because we know that when the officer goes to investigate, it could not have been that person. But when he's going to do his investigation, he's knows one of the black males has a gun, but he doesn't know who. So he has to do the investigation. But for him being able to do it, they all take off.
If I may, Judge. So my argument is just based off of the OR. My understanding is that they're going outside of the OR. They could supplement this case if they want to. They could refile it.
I really want to know what all I want to know is what the officer knew about who had the gun when he went up there. Did he know anything about which defendant had it?
It's not in the OR, Judge.
There's the problem.
Understood. Okay.
If you find something different later on, then reapproach and show me, and then I'm happy to redo probable cause. If you can show me that there's something different, I'm always happy to re-entertain it and do it again. But
the only thing I can show you is what's in the OR, where it says the description of the black male wearing a black shirt and two-tone colored jeans.
And to be clear, Judge, we will be contacting the officer again today and having them file a supplement to correct.
You're telling me that when the officer rolled up to all those people out there, he knew the person that had the gun was wearing a black shirt and two-tone colored jeans? Is that what you're saying?
I don't know what the officer knew, Judge.
Because if that's the case, if he's going up to the group of kids and knows that the gun holder was wearing that, and he's not wearing that, then we know it's no probable cause.
All I'm stating is what's in the OR. I don't have the answers that you're asking for. He's getting the answers based on a phone call that I don't have access to. I don't have.
Yeah, well, I'm not considering that. I don't care about that.
So then
I don't care what he's telling me. All I care about at this point is what the officer knew when he goes up to do his initial investigation.
Okay, and Judge, just to be absolutely clear, page 7 indicates specifically who told the officer that description, and it's the second witness, not the first witness that they had information about when they rolled up. The second witness that identified him dumping the gun.
Who is the second?
It's just somebody that identified him as there's a juvenile male just dumping a gun.
Is this just a random person that's in
I
the
believe so.
in the Texaco?
This is a third party witness.
So the first witness is the gas station attendant.
Yes, sir.
Second witness is just a citizen somehow sees the gun and alerts authorities, hey man, I see someone with a gun.
It's alarming.
And he didn't give a description?
They did. This person did give a description. They said black male with a black shirt and two-tone jeans.
So he does say that to the officer?
No, Judge. That was after the people had already run. The only thing the officers knew was what they had in the first 911 call was that a black male identified said that he did it, but there was 3 of them and 2 Hispanics and a white male, and they all ran. So they had PC to at least stop the.
What did the 911 caller say as far as who had it?
They just said, Morgan, can you clarify?
Can we play it?
The 911 caller didn't give an exact description. He said, and I will say, it kind of appears as though English may not be his first language. When he's speaking to the person on 911, he says that there was a group of juveniles that came to the store. One of them had a gun. He asked if he was licensed. The individual said no, and he asked them to leave, and then he called the police, and he said it's a group of 4 men.
This is the actual attendant. No, but the gas station attendant.
Yes.
The person working it.
Yes.
And he doesn't give a description at that time.
He doesn't. The 911 operator does not ask, what is the person wearing?
I mean, what?
But he said that they walked outside and that they're in the parking lot. Like the same people that were just.
So then the officer goes to do the investigation. They all bolt.
I don't think they all bolted.
Oh, they didn't? Who bolts?
My guy bolts.
And then the person with
They all bolt?
Yes.
they all of them do. Did they all get charged with the?
I don't know if they caught anybody else. I'm telling Judge, and the reason why I brought his criminal history is because I'm telling you, he's known in the community.
Right.
He's
That's how they
known.
got to him.
Yeah.
If they all
They know.
bolted, why didn't the guy with the gun get charged with evading as well? If they all
They got the felony charge. That's why. It would have been a dick move and charge him with the one. Again, they could have, but he's lucky they didn't. You know, that's like you get a DWI and then they give you a speeding ticket on top of it, right? That's just insult to injury.
I just make the argument.
I'm sorry, but had it been different, I have no problems finding probable cause in cases. It come up after about an hour of argument here.
And maybe it goes a different way once we actually get the 911.
If you find anything else, I'm happy always to revisit. But is it Royale?
And it's like that. Yeah. Oh yeah. That's how you say in Spanish.
Oh yeah.
Yeah, that's how you say in Spanish.
With a J, that's right.
Yeah,
Right.
They were Spanish.
So I am going to find that there's probable cause. Okay. When you hang with dogs, you get fleas.
No.
You now know.
I know now.
Just listen. You are on bond for 2 very serious felony cases, right? Is it just 2 or is it like 3?
3 other cases, Judge. I'm just representing.
No. You shouldn't be hanging out with dogs because you could get in a lot of trouble. Even standing there. Life is more difficult for you because of who you are, and you need to be aware of this. You already are behind the gun, and you're only making things worse.
Yes, sir.
As you now know, they might file felony charges against you or, revoke the bond. So,
Yes, sir.
as it stands now, if you become a danger to my Houston, I'm going to put you in jail.
Oh,
You
yes,
need
sir.
to know that. No weapons. Do you understand?
Promise you won't see me with no gun, sir.
All right. Did you file?
I can follow that now, Judge.
It's just no weapons.
Sure.
And then after that, we'll just reset it. Stay in touch with him. I've given you a lawyer.
Thank
If
you,
you don't stay in touch with Ricardo and he tells me he can't get a hold of you, likewise. Okay?
Yes, sir.
Okay, man.
I appreciate